Hello, everyone. Happy Christmas Eve. We have had a bit of an early Christmas present from Wayfarer. They have filed their opposition to Blake Lively's, I think it's the 10th sanction motions. Yeah, I'm pretty sure we're on 10 now. And it's, to be honest, all these sanction motions are really what's making this lawsuit, among other things, but this for me is what's making it turn into a bit of a circus. So we have an opposition, and it's quite a telling opposition. So let's go through it. Okay. Dear Judge Lyman, as counsel for Wayfarer Studios, etc., the Wayfarer parties, we write in opposition to Blake Lively's motion for sanctions and other relief concerning the deposition of Nicole Alexander. So, yeah, they're going to explain. So, Nicole Alexander is one of Wayfarer's designated experts. Ms. Alexander is an expert in digital ecosystems, AI-mediated brand perception, and online reputation measurement. She was designated by the Wayfarer parties to rebut certain expert reports concerning whether the social media activity regarding Ms. Lively from August 2024 through February 2025 was caused by a coordinated negative manipulation campaign, as Ms. Lively alleges, or was the result of organic public engagement and entertainment industry media cycles. Okay. On December 15th, 2025, Ms. Alexander was deposed for 7 hours by Ms. Lively's counsel, Meryl Gavernsky, about her expertise and her expert report. Okay, and we've got a footnote. Ms. Alexander's deposition had nothing to do with Ms. Lively's sexual or romantic history. Of course it didn't. Why would you ask these questions to someone who's dealing with, what was it? AI mediated brand perception and digital ecosystem. Why would questions be posed about sexual or romantic history, for fuck's sake? Nevertheless, the motion attaches a self-serving letter from 3 months ago sent by Ms. Lively's counsel to the Wayfarer Party's counsel, complaining erroneously about certain deposition questions purportedly concerning her sexual or romantic history. The questions at issue therein pertain to Ms. Lively's reputation, which she put at issue. And that's what I said. In the UK, this stuff is, sexual history is kind of fair game. It may not feel fair to like a rape victim or someone who's, a sexual assault victim, but it's actually important to know, to ask these questions. Given that Ms. Lively did not seek relief from the court months ago about any purportedly improper lines of questioning and is not seeking such relief now, the motion seemingly was filed solely to generate inflammatory headlines and falsely besmirch the character of the Wayfarer Party's counsel. Yeah, and I agree with that. I said that when I read the motion for sanctions. I was like, oh, here we go. This is the PR move. And talking about Justin Baldoni with an incident that apparently occurred with him with a young teenage girl, getting that into the filing for what? It has nothing to do with this issue. And they've cited some news headlines. God, that's wild. Okay. Rule 30C2 of the Federal Rules of Civil Procedures provides that an objection during a deposition must be stated concisely in a non-argumentative and non-suggestive manner. Under Rule 30D2, courts are authorized to impose sanctions for conduct that impedes, delays, or frustrates the fair examination of the deponent. Ms. Lively submitted to the court only 35 pages from Ms. Alexander's deposition transcript, a mere 10% thereof, presumably to create a false narrative. We submit herewith the entire transcript so that the court can see that Miss Alexander's deposition was not impeded, delayed, or frustrated. I will be going through that transcript. I won't be doing it now because it is 180 odd pages long. So I will have to do like a part 1, a part 2, and a part 3, I think, and maybe even more parts to see how we go. They don't take long, particularly to get through each page, but 180 odd pages is still a good couple of hours worth of reading. So I will do today this letter and the declaration. I'm not sure if there's anything else, and then I will do a separate video which will be in multiple parts then to go through the full deposition transcript. Okay. Upon reviewing the transcript, the court will see that the Wayfarer party's counsel concisely and appropriately objected to this form of certain questions, did not utilise speaking objections, and permitted Miss Alexander to answer every question except for one topic which is addressed below. The motion does not identify any material area of testimony. Ms. Gabernsky sought to explore that she was prevented from exploring by counsel's objections. Okay. A review of what Miss Lively labels frequent speaking objections demonstrates the triviality of the motion. Although Miss Lively alleges that the Wayfarer party's counsel interrupted the deposition to ask whether Miss Alexander should review an exhibit, the cited examples show that A. Miss Lively's counsel, Meryl Gabernsky, was unaware Miss Alexander had amended her expert report, erroneously claimed that the amended report had not been served upon her. It had been a month earlier. And the Wayfarer party's counsel professionally steered her in the right direction. B. Ms. Alexander, who had never previously been deposed in any litigation, let alone remotely, was advised to download an exhibit so she can review the entire document as one would do in person, rather than review only the portions viewable to her through Ms. Gabernsky's screen sharing. And C. Ms. Gabernsky asked Ms. Alexander to summarize a lengthy article cited in the expert report. The witness was confused about whether she was being asked to summarize it offhand, from memory, and when the Wayfarer party's counsel asked for clarity, Ms. Gabernsky launched into a tirade instead of clarifying what she was asking Ms. Alexander to do. Deal. During one exchange cited by the motion, Ms. Gabernsky interrupted the witness, who was confused by the line of questioning, and the Wayfarer party's counsel suggested that Ms. Gabernsky listen to the witness so that the questions could be clarified. Okay. Notably, at the start of the deposition, Ms. Gabernsky failed to instruct the witness, as is standard in depositions, that if she did not understand a question, she should say so, and Ms. Gabernsky would rephrase it. As for Miss Lively's criticism that Miss Alexander was sometimes instructed to answer again, such instruction is not improper. Examples of improper speaking objections are those made by Miss Lively's counsel, Ezra Hudson, at the deposition of non-party Jenny Slate. And that part of the declaration is under seal. Miss Gabernsky never instructed Miss Alexander at the outset of the deposition that she could take a break, which is routine. Miss Lively nonetheless inexplicably takes issue with a suggestion after 2 hours of questioning that Miss Alexander and the stenographer be provided with a break during the deposition. And just to put that into context, right? The maximum amount of time you can depose a person in one day is 7 hours. So 2 hours is actually quite a lot of that 7 hours. So asking for a break at that point is not unreasonable. After such break was requested by Miss Alexander's counsel, Miss Gavronsky proceeded to ask another question, then utilized the guise of a pending question as a basis to refuse a break, and ultimately was proven wrong when the stenographer confirmed that no question had been pending. In sum, the questioning of Miss Alexander went relatively smoothly, especially after the parties' counsel conferenced with the court during the break, and Miss Lively failed to show that the deposition was impeded, delayed, or frustrated in any substantive manner. The only time Miss Alexander was instructed not to answer was based on privilege/work product, and in connection with questions concerning her conversations with separate counsel about this case. Rule 26B4C protects from disclosure counsel's communications with testifying experts, and they've cited Lyman's own case for that. In response, Ms. Gavronsky improperly attempted to debate counsel during the deposition about the instruction to Miss Alexander to not answer. And we got a footnote. Ironically, it was Ms. Gavronsky's own improper attempt to debate counsel during the deposition that prompted Brian Friedman's request to her that she cease such misconduct. Okay. In violation of Rule 4C of this court's individual practices in civil cases, Miss Lively's counsel failed to meet and confer after the deposition or even during a break therein concerning the propriety of the objection. The motion should be denied for that reason alone. Had Miss Lively's counsel adhered to the court's individual practices concerning the resolution of discovery disputes, we would have agreed to a short continuation of Miss Alexander's deposition via remote means and on a mutually convenient date, limited to questions concerning her communications with the separate counsel, identifying facts or data that such counsel provided to her and that she considered informing her opinions expressed in the report. We so stipulate now. The motion to sanction Brian Friedman and the undersigned is frivolous because it is based upon an alleged ongoing pattern of deposition misconduct, but cites no prior conduct by either attorney at any deposition. And as a footnote, the citations to Jamie Heath's deposition transcript concern an entirely different situation where counsel was not responding to any pending question but raising concerns about lengthy breaks that Miss Lively's counsel was taking. So you remember that was absolutely hilarious deposition transcript where Ezra Hudson lost her mind over the fact that she had 9 minutes left of deposition time, but wanted to take a break at that point instead of just getting on and getting through those 9 minutes. It was just absolutely wild. Furthermore, the motion cites cases in which the attorney deliberately violated repeated orders of the court, engaged in prolonged and unnecessary argument regarding the relevancy of a simple question, and instructed the witness not to answer on relevancy grounds, or was held responsible for its client's violations of orders to produce documents, none of which Miss Lively even alleges or demonstrates that either Mr. Friedman or the undersigned being Kevin Fritz, because he's the one that signed this document, so he's referring to himself as the undersigned, did. The only ongoing pattern is Miss Lively's use of the media to disparage others and distract the public from the legal issues at hand. Finally, someone is saying she's just using this as media. I wonder what the judge will do with that. Okay. So let's see. We have Kevin Fritz's declaration. It's not too much to it, but we'll go through it anyway. So I, Kevin Fritz, pursuant to, etc., etc. I'm an attorney admitted to practice before this court. And he talks about, the law firm he works for and who he's representing, etc. I respectfully submit this declaration in opposition to Blake Lively's motion for sanctions and related relief in connection with the deposition of Nicole M. Alexander. Ms. Alexander is an expert in digital ecosystems, AI-mediated brand perception, and online reputation measurement. She was retained by the Wayfarer parties to rebut certain expert reports concerning whether the social media activity regarding Ms. Lively during August 2024 through February 2025 was caused by a coordinated negative manipulation campaign, as Ms. Lively alleges, or was the result of organic public engagement and in entertainment industry media cycles. A true copy of the transcript of the deposition of Ms. Alexander, taken on December 15th, 2025, is attached as Exhibit 1. Now, the close of deposition was the deadline for expert depositions was on the 12th of December, if you remember. With this one, there was an extension to that deadline because this particular expert was unwell on the day of her deposition, so they moved it. And the footnote that accompanies that says that the specifics of an illness suffered by Miss Alexander have been redacted, so the information about why she was unwell and unable to sit for her original deposition, which I think was on the 10th or 11th of December, is all redacted. And then it also says, true copies of excerpts from the deposition of Jenny Slate taken on September 26, 2025 are attached as Exhibit 2. Those exhibits are under seal, so we are unable to see them yet. I think that's all there really is now to talk about this. So I will start a series of kind of less than an hour, maybe 45 minutes per video to get through the deposition transcript of this witness, because I'm don't know about everyone else. Some people find it boring, but I find this stuff really interesting, and this is this is really important evidence for trial in particular. So let's see what this person says about her digital smear campaign, etc. Because she's going to be the one to sort of pull apart. She's not just going to form her own opinion. She is also going to be looking at the expert reports of people like Lively, and she will be kind of rebutting what Lively's expert says. Lively is saying, well, this was a smear campaign. Wayfarer saying, no, this was all organic. And I'm dying to see actually how she kind of, she's going to be questioned about Lively's, going to be questioned by Lively's counsel. So I'm curious to see how that goes. It gives you a bit of a sample, a bit of a taster of what's to come at trial, how Lively's counsel will approach, questioning kind of opposition, both in terms of witnesses and experts. So I will be going through the whole thing. I won't be just cherry picking, spicy tea or interesting things that make catchy headlines. I think the whole thing is needed for context. But it's a long document, so it's going to take more than one video. So yeah, I'll get started on that, I think, and that will probably come. Might do part 1 tonight and then continue with part 2 tomorrow then. All right, guys. I will catch up with you later.